everyone. This is Grow with Megan O, episode 4. Okay, this week we're going to be talking about what happens when divorcing parties decide that one party can stay in the home and then years down the road they want to go sell the home. What's going to happen in that scenario? As you recall, I've recently obtained a certification called the Certified Divorce Real Estate Expert from the Alumni Institute out of California. This has given me specialized training in how to work with parties going through a divorce and how to assist in the real estate portion of cases in family law, as well as in probate cases. Those cases too can involve real property that is going through disagreements with members of the family, for example. All right, today though, we're going to focus on what happens if the parties agree one party can stay in the property and keep the property. They divorce, it's finalized, they're no longer married, they go on down the road, and then one of those parties wants to sell the property. What's going to happen? Well, here's the short answer. They cannot sell that property without the involvement of the other person whom they divorced. In Texas, we are talking about Texas. Texas is a community property state. So when the parties bought the property, even if the property was only in one party's name, the title, or even if they weren't on the title, actually, it's a community property state. And it's very possible that that party who's no longer residing in the home, who agreed to let the other party stay in the home, may still have equitable interest in that property. So if it wasn't discussed in the divorce, and the parties did not make some kind of agreement in their final decree of how they were going to handle, let's say, proceeds from a sale of the property down the road, you might have a cloud on title until this is resolved. A cloud on title means an issue, something that's popped up that says, hey, Joe, who divorced Sally 10 years ago, but they never did anything about that in the decree, might still have an interest in this property and might still be entitled to receive proceeds. What's going to happen? Well, then you have to go through the legal steps to decide what happens in that scenario. Now, how can you avoid all this? Well, here's your tip. Here's how you can avoid it. In your final decree or some other order out of your divorce, you can specify exactly what's going to happen in the event that the property sells down the road. So the parties agree, let's say the house is owned outright and Sally gets to stay in the property and Joe's going to leave. The house is owned, there's no mortgage payment. This is an example. Sally gets to stay, Joe gets to go. But in that decree, they also say if Sally sells the property whenever, anytime between now and her death, then Sally owes X amount to Joe. Well, that's stated in the decree. So when Sally does go sell the home, that's going to come up in a title search and they're going to see that information and they're going to go and pay Joe whatever that amount said. That's just one example. But the point is, in your final decree or some kind of final order in your divorce, it will dictate exactly what's going to happen with that property should it sell after the divorce. Does that make sense? I hope so. If not, feel free to reach out to us. Check out our website. If you're an attorney and you're seeing this, you can go to our website and click on CDRE under legal, and you can click on more resources for attorneys, find some information there, or feel free to reach out to us. All of our links are below, and we appreciate your time. This was Grow with Megan O.